This is Peter Snodgrass, Head of Agriculture at Shakespeare Martineau Solicitors. Welcome to the podcast, which we have done on agricultural tenancy reform. I'm joined by my colleague, Jenny Wheeldon, Legal Director. Welcome, Jenny. Would you like to just do a quick scene setter?
Yes, of course. Hello. So we're meeting today to discuss agricultural tenancies. They come in various forms, from the Agricultural Holding Act tenancy to farm business tenancies, grazing licenses and other structures. The main reason for discussing today is following the introduction of the Agriculture Act 2020, we have seen some reform, some introductions for change to that scene. And we thought we would discuss today what the main changes are, the policy behind it, and what else we might like to think about.
Thanks very much, Jenny. The webinar will follow in the following rough order. First of all, an introduction about different kinds of land occupation agreements. Then we're going to be talking about policy objectives. Then the detailed reforms in the Agriculture Act that Jenny's referred to. And then finally, will it work? And what are the questions in our minds about how these policy changes are going to impact on tenanted farms. So to begin with, land occupation agreements. There are two main kinds of tenancy: the Agricultural Holdings Act tenancy, which is governed by the Agricultural Holdings Act 1986. And that's the traditional style of tenancy, which gives lifetime security to the tenure and implies a lot of terms into tenancy agreements. They also can carry succession rights. And then you've got farm business tenancies, which were meant to take over and did take over to some degree from AHA tenancies in 1995. And these were much more designed to allow freedom of contract between the parties so that they can simply agree the terms that they want with some constraints. Those arrangements are both full tenancies where the tenant has exclusive occupation of the holding. So the landlord takes the rent, the tenant does his business on the holding. There is also, just to touch on them briefly, a grazing license, which is technically shared occupation between the landowner and the grazier. So the sheep graze and take the crop, say, but the landowner retains possession. And then very popular these days is contract farming, under which the landowner enters into an arrangement with what you could call the farmer, but of course you can't call him the farmer for the purposes of the agreement, but the person who will provide the machinery and kit and sometimes and often the farming expertise to be able to bring a crop, say, to fruition and harvest. And then there's also another possible arrangement is share farming agreement, which is slightly different from contract farming. I'm not going to spell it out further. If anyone's got any queries about that, we can discuss it, but it's not the main focus of today's talk. These are just different possibilities, all of which are used in England and Wales for either shared occupation or granting occupation rights to another person. So, Jenny, would you like to give an outline of the policy objective?
Absolutely. So we've looked at what we have currently as tenancies, and perhaps it's worth looking at what the policy is and what we're looking to achieve from reform. So we've got the requirement from the government to hit carbon zero by 2050, and the environmental changes that would come about for us to achieve that, efficient food production, and the delivery of change to be more efficient farmers, and helping also generations to retire and the young new entrants to farming to be able to come onto the scene. So with that landscape of policy change, shall we look now, Peter, at what some of those key changes are?
Well, it's quite simple in the sense that now you don't have to have a retirement age. You can just be any age you like when you retire from a tenancy. And just to put it in context, before, if you wanted a close relative to take over your tenancy, you had either to have reached the age of 65, or you had to have an illness or some problem of that kind, which meant that you couldn't or couldn't be expected to continue as the tenant. And then your close relative could make an application. Well, now you're not going to have attained the grand age of 65. You can make the application, or your close relative can make the application at any time.
What do you see the benefits of that, Peter? Having no age to retirement?
The main benefit, Jenny, is that now a farm business can make decisions about when to seek a succession tenancy without regards to the age of the current tenant. So that means a tenant in his 50s or whatever can begin to think about taking or handing over his tenancy or her tenancy to a close relative. That is very helpful because once the tenancy has been handed over, then the new tenant doesn't have to consider having to comply with all the conditions that you have to satisfy in order to gain a succession tenancy. So it gives you a freedom once you've got a succession tenancy under your belt, which you don't have until there. Because I've had clients, for example, who have had a lot of off-farm contracting income. That made it very difficult for them to, for the son to qualify for a succession tenancy. And so if they had been able to secure the succession tenancy earlier, then the son would have then been free to do his off-farm contracting as much as he liked, because he wouldn't be constrained with the need to continue to comply with those conditions. So it should enable additional flexibility for tenants.
Yeah. And also helpful that there's no upper age limit either for those that start families in later life.
Absolutely. Look in both directions. Moving on to the second major change to the regime, what's called the commercial unit test is to be abolished. So Jenny, what do you say about this?
So traditionally, where we have a succession to an Agricultural Holdings Act tenancy, the applicant needed to be able to show that they derived their income and livelihood from the one holding that was the subject of that application. The removal of the commercial unit test means that farmers now that have an Agricultural Holding Act tenancy now no longer need to be concerned that the individual that's going to succeed them only works and only has an interest in that particular holding. So, for example, there may have been families where there's more than one son or more than one child that would be a successful applicant, but in their lifespan, they've wanted to go off and have farm business tenancies or purchase other land, and that would have actually been detrimental to the succession application. So one or more of the children may have been held back from obtaining another land interest with the hope of them having the Agricultural Holding Act tenancy, which obviously came with uncertainty and may have been considered unfair by others. By removing this layer of complexity, it allows for much more, for farmers to have much larger units, take into account lots of different land holdings, and I think has the ability to be much more flexible about what farmers can do and still preserve their Agricultural Holding Act tenancy.
Yes. So that's very good from what you're saying. It's going to be encourage flexibility amongst people who may have a claim to a succession tenancy. And I just comment in passing that it also means that we don't have to go through the commercial unit assessment, which was an incredibly involved and difficult calculation sometimes, and rather weirdly related to the average income of farm labourers and this sort of thing, which we now would not, from when this is introduced, would not have to engage with. So
yes, and I can see how the abolishment of the commercial unit test will also help to deliver those policy objectives, allowing people to be more productive, farming larger areas than just within the holding, and ultimately bring about good environmental changes and reducing carbon footprint.
Yeah, I'm sure that that's going to be the case, and it'll be just so much better for the flexibility of the sector as a whole, for people not to be ruled out just because they happen to have a certain other bulk of land, preventing them from getting a succession.
Yeah. And in terms of to the sort of policy objectives, one of the other introductions, Peter, was the business capability test. I don't know, would you like to tell us a bit more about that and how that's going to impact?
Well, the traditional test for a succession was one, eligibility, which had three parts to it, and then suitability, which has always been a slightly woolly sort of one, because it's to do with things like the farming competence, the character, the financial standing, the health. I say these are woolly, but because they're all slightly vague. And what they're aiming at is that this is overall, as the word says, a suitable candidate to take on the holding, because a landlord shouldn't have foisted on them a tenant who is not up to standard. And so that was a sort of a laudable attempt to control that. I think what people have felt for a long time, though, is that it's quite a low bar, and it didn't require very much to satisfy it. And also tribunals were probably leaning in the direction of the applicant for the succession more than to the landlord. I mean, I know that they were all very neutral and so on, but that was the tendency, and the bar itself was, not terribly high. So in addition to those tests, which are basically repeated in the new provision, there are going to be requirements for a high standard of efficient production and care for the environment on the part of the applicant. So they've got to demonstrate that they can deliver this. And it's thought that this is going to be much more like a sort of competitive tender for a tenancy. It's not just by default, but he's close relative, therefore it goes through. They've got to show that they've got ideas, that they've got plans, they've got commitment, in addition to all the other things such as financial standing and character and so forth, and farming competence, to show that they're going to be able to make a go of this holding. And this is a great advance, I think, for landlords of AHA tenancies, because they will be able to really put the applicant to the test in a way which hasn't really happened before.
Yeah, and also bring out some exciting challenges for the tenants as well, to really think about what their business could be and how they could farm in a different way. I mean, we see so much now with technology, and I believe the Young Farmers Association recently had a Zoom meeting about introduction to technology and how actually some farmers may find themselves controlling their holding from behind the computer screen in times to come. And I just think that sort of foresight to the future and really thinking about how we can bring those different elements in to managing tenanted land, it could be really exciting for landowners and tenants, actually.
So you're telling me that we may have farmers who don't have dirt underneath their fingernails. Exactly. And very big, I mean, shake a farmer's hand of a certain age and their fingers are usually about twice the width of mine. And that they might struggle with actually typing on a computer, I think. Yes, so that's interesting. And when we were discussing this before, Jenny, we were sort of thinking maybe, of course, whenever there's a succession application, there will be negotiations going on between landlord and tenant. And maybe this might be an opportunity for tenants to push or prospective tenants to push to say, this is part of my program. I want to develop a fish farm, or I want to develop, I don't know, an off-road motor vehicle course, or something like that. Something not traditionally done on the farm. And I think it could generate some pressure, maybe, or in a healthy way, on landlords to be more embracing of changes to things.
Absolutely. And certainly if these capability tests are going through tribunal and being put to the test, it would seem a bit it wouldn't seem to fit really if the tenancy that the successor then came out with didn't allow them to do the things that were in their business case. For example, they were succeeding to an agricultural hold in that tenancy that required certain elements of farming to be done by hand that harked back to the 1970s agreement, whereas their future plan sees embracing new technologies.
Yeah, I think that's absolutely right, and it will be very interesting to see what happens. And we must say that this new suitability test will come in through regulations, which are not in stone yet. They're still being consulted on, and so it will be important to see how that works out. That just another thing to mention is that the new suitability test is going to be brought in to effect at the same time as the commercial unit test is abolished, so that the two sort of go in hand. But it will be very interesting, because there's always been the ability for a tenant to apply for a change to the terms of the tenancy agreement if circumstances have changed since the original one was entered into. But this could really nudge it, give it quite a lot of power and teeth, I think.
Absolutely. And it sort of fits with the further reform that we've seen around sort of restrictive clauses within tenancies, and the ability to now put that for dispute resolution, and the sort of ability to ask a third party as opposed to going for arbitration. So that's it's all sort of moving in the same direction, it feels.
Yes, absolutely. So you've touched on the problem of restrictive clauses in tenancy agreements. Do you want to just say a little bit more about how the Agriculture Act has changed those?
Yes, so we're seeing the Agriculture Act has now brought in the ability for tenants to have certain clauses that are restrictive. For example, those that prevent financial assistance, so the ability to go forward and make use of the new ELMS system that we're seeing coming in, or for in order to comply with statutory requirements. So those restrictive clauses can now be put to dispute resolution to resolve in the event that the landowner wasn't prepared to agree a variation to those.
So just sort of unpacking that a bit, Jenny, you've got a situation where, say you've got a clause in a tenancy agreement which says the tenant will not enter into any grant or subsidy, or probably not subsidy, but a grant or environmental scheme without the consent of the landlord. And that's been a real constraint on the tenant in the past, and we've seen lots of tenancies like that. So what would happen in that situation?
So traditionally, the tenant could apply for arbitration, but the Act now introduces the ability for the tenant to apply to what's called a third party. It defines a third party within the Act. And that is an individual that is registered either as a RICS chartered surveyor with the CAAV, or with the ALA, the Agricultural Law Association. So an individual registered with one of those organisations could come in as a third-party expert to help determine the dispute. And I can see how there would be some benefit to that, because we see that with lots of other contractual agreements, that third parties best suited to determine the issue and all the intricacies of it are able to then decide on the facts presented to them. And personally, I can see why that would be attractive to both landlord and tenant in these circumstances.
So this is going to be really important then for tenants who would otherwise not be able to access these environmental schemes which are being rolled out by government. And so the landlords are not actually going to be able to prevent that happening.
Yeah. Would not without justification, no, and it fits again back to the policy objectives. Really, if we're trying to create a more efficient way of producing food, we're trying to reach carbon net zero, we have to be able to access the government schemes and farming the ways that access those schemes, and to be prevented from doing so because of an archaic agreement. The two just don't sit hand in hand to me.
Yeah, absolutely. And we'll be talking a little bit later about whether it's gone far enough. Now, you touched on how disputes can be resolved, and it's a bit of a technical point, but it's actually quite important. And this part of the Agriculture Act is one of the only parts which applies both to Agricultural Holdings Act tenancies and also farm business tenancies, because it liberalises, it just makes it much more open to third-party determination. And as you said, Jenny, these third-party independent expert, typically, decisions have become much more popular. The one area in which they're going to be very, very welcome is in the context of rent reviews, because these have been so expensive, and both landlords and tenants have suffered under the cost of actually going to arbitration on them, so much so that the deal has to be done, really, but not necessarily on a very good principle, because people just don't want to spend the money on the arbitration. So to have what we hope will generally be a much cheaper way of resolving it will be a great advantage. So, Jenny, let's look at some of the things we've been mulling over and go through some of the issues which we think are very pertinent at this stage.
Yeah, so we sort of touched on rent reviews there just as we finished up on the policy review. So do you think it is fair, in light of a changing tenancy landscape, for agricultural holding acts tenancies to have a sort of lower rents?
I think that's a very interesting question, and it's one which has been very contested about whether, how the AHA rents sit alongside farm business tenancy rents ever since FBTs were brought in, really. So what we have, or we will have, is still the Schedule 2 rent review provisions of the AHA, which will apply to agricultural holdings tenancies. And at the same time, an increasing pressure on landlords to liberalise the restrictions on what tenants can do. What one feels about the whole sort of direction of travel is that we're going towards a more market-orientated way of sort of running tenancies. And I think it's a natural question to ask, do we still want to have a completely separate review system, which is quite detailed and slightly difficult to construe because it's got so much to it, and what takes priority over what is not that clear. You compare it with the farm business tenancies, which simply say market rent, and we've got quite a simple formula. And one could question why landlords under one should not do as well as landlords under the other. So I would expect there would be some pressure, maybe through legislation, to equalise, I suppose, the two kinds of tenancy in that respect, which would remove, what has been seen as one of the strong benefits of an AHA. I don't know. What do you think, Jenny? Do you think it would be fairer, stroke better?
Whether it would be fairer or better, I think I don't know the answer to that, but I can definitely see the question being asked again is, would market rents be fairer under agriculture, under the AHA tenancies? And certainly it may benefit both parties, because we may start to see some more investment from landowners into the holdings and into the new ventures of their tenant, if they can see some immediate financial rewards.
That's a good point. Yeah, absolutely. And as we well know, sometimes landlords are very reluctant to invest in AHA holdings. So interesting. Yeah, that's a very pertinent point. Now, another thing which came up is this idea of new entrants coming into it. And when the Agriculture Act was being debated, mooted, certainly there were ideas about being able to extend the close relative definition, or to include people other than close relatives. How did you see, or how would you see that as panning out? It hasn't been adopted.
No, it hasn't been taken up. But I actually thought that the proposals that were put forward were quite fair, actually, because there was talk about allowing grandchildren to come within that pool, or people outside of the family, but then with this like 25-year cap, so that we weren't extending the AHA tenancies in time, but we're allowing sort of the farmer, where they'd sort of come to the end of their farming life, that ability to move the tenancy on or assign the tenancy without clinging on to the end, because they didn't want to see it go away. And potentially there could have been a market for that agricultural tenancy, where the retiring farmer could receive an end payment for retiring and passing on to next generation or another individual, and that to me sits at quite nicely. I mean, we're not touching on it today, but we're talking about the sort of end of the basic payment scheme, and the option there for farmers to perhaps take a lump sum retirement, and that to me, the two sort of would have sat quite neatly together.
Yes, it would, and really enable new entrants to come in at hopefully an affordable level, maybe, rather than having to buy land, which is really not feasible. Also, we've got these abilities of a tenant to challenge certain restrictive clauses, but it's very limited. It's only for if there's a clause which restricts them entering into basically sort of environmental payment or other sort of grant schemes, or if they're they need to breach the tenancy in order to comply with statute. But do you think that there might have been scope to go a bit further than that?
Absolutely, and also crucially, that doesn't refer to farm business tenancies either, that could also have those clauses in. So absolutely, because I think that the landscape that we have ahead of us could be varied and different, and diversification could come in many forms that doesn't fit the letter of what those of us drafting the tenancies foresee at this time. So I think, I could foresee that it could have gone further, and it would be really great if there could have been some provision for further challenge, where we actually were justifying the policy reasons for bringing in this change. What sort of changes would you like to have seen, Peter?
Yes, Jenny, that's interesting, because when the Agriculture Act was being debated, I went to a meeting for professionals involved in agriculture, organised by DEFRA and the ALA together, to sort of get a sense from the professional community what we thought about some of these changes. And one of the ideas was there would be a more general right to challenge a clause which was constraining the farming of a holding. And certainly I thought that was a very interesting idea. It would be a bit of sort of social engineering in one sense, in the sense that it's just it would be forcing landowners and landlords to move with the times, if you like. They wouldn't be able to sit, as some of them have, on, a clause which says, for example, this farm shall be used for agricultural purposes only. Plumb. That means anything which isn't agriculture is ruled out, even if that could really be of benefit to the tenant. Of course, the irony is that in many cases, that would also be a benefit to the landlord, because they've got a diversified stream of income for their tenant, possibly a more enterprising tenant, and a more secure payment of rent and covenant for building repair and that sort of thing. So I thought it was a very interesting one, and sorry that wasn't left as an option for the regulations which are yet to be made.
In terms of farm business tenancies then, and the sort of option for diversification and changes, is there anything that you think that could have been done to improve the desire to grant longer farm business tenancies, to encourage longer term investment in the holdings?
I think that's a very difficult one. I'm thinking of the Tenant Farmers Association, who suggested a few years ago that maybe inheritance tax relief would apply only to farm business tenancies over a certain length, so that would give landlords a real incentive to do it. I think it's difficult. I think the one point which we have touched on is that if the rents will go up alongside, a diversified and invested in holding, because the tenancies, he's going to get benefit from it, then landlords will be encouraged maybe to let for longer terms. It will obviously depend on the circumstances of the landlord and tenant, and the objectives of the landlord. But
I can see how for some of the policy changes that the government are looking to introduce, especially around the creating carbon neutral society, that we do need to see a longer term tenancy, because I just don't know how you can guarantee that reinvestment back from the land with the 2-year arrangements, and whether there needs to be some sort of flexibility around break provisions where longer tenancies are granted to try and encourage that.
And so I perhaps would go back also to just the mentality of the landed estate or the landowner who's thinking about granting a longer or a shorter tenancy. If their perspective is that they will get a decent return from granting a longer tenancy, with the other benefits, because they do get tax benefits at the moment as a landowner if they grant a tenancy, then if the sort of pre-death, if you like, non-inheritance tax returns are also stronger than perhaps they've been perceived to be in the past, then that's going to encourage landlords to let for longer terms. But the mentality of the landowner obviously is very, very important, because there are some who are really committed to having a tenanted estate. There are others who are not so committed to that way of managing things. So, Jenny, could you leave us with a summary of your thoughts about these reforms to the tenancy law?
Yes, well, it feels like it's been a whistle-stop tour of the tenancy reform. And there's much that we've touched on and much that's left further questions for answer. And perhaps we will see further changes to come when the regulations that follow the Act come into force. So I think that's what I'm going to be watching closely, is for that informed information to come through.
Great. Well, thank you, Jenny. It's been very nice to chat these things through with you. I'll just take this opportunity to advertise the fact that we're doing another session. It's a webinar on the 22nd of April at 9:30, and that's to do with farm partnerships and various aspects of how they operate and things which need to be looked out for, particularly at this junction. But in the meantime, Jenny, thanks very much for chatting these things through, and goodbye to all, and thank you for listening.
Thank you.